All right, so bear with me a moment because we're about to talk about the C word, and that is custody. Now, in Illinois, custody does exist in many realms, but for purposes of divorce law, it doesn't exist anymore. Now, people still use the term, so I'm going to do my best to explain what does it mean for you and what does it mean for the court system. Really, custody was something that people always fought over. And they would say, I have legal custody, we have shared custody, joint custody, summer custody, all of these different terms. But quite frankly, people didn't really understand what they were arguing over. So in Illinois, they changed the language and it's now called allocation of parental responsibility. So something I'll just sometimes call APR. Essentially, what that means is decision making. Who makes the major decisions for the children? And in Illinois, there's four major decisions, and in no particular order they are healthcare, religion, extracurriculars, and education. And then we break each one of these down and we go through them one by one. Can you guys make joint decisions when it comes to religion? If yes, we can say you have joint decision making when it comes to religion. Can you do it for healthcare? And on and on. We go down the list and we identify where are the discrepancies. Sometimes people can agree on three of them and one of them they can't, and that's okay. You make those actual decisions based upon your unique circumstances. So once you have decision making aside, then you have parenting time. And the best way I like to explain parenting time is it breaks down into sections. You have regular parenting time, which is essentially school year. What is the regular schedule while the children are in school? Then you have holidays and you have breaks. So breaks would be spring break, summer break, fall break, winter break, things like that. What we need to do is just go through each one of those components. Same thing with holidays. How do you want to split up your holidays? Do you want to do them evenly? Do you want to alternate years? Every situation is different and it should be based upon your family and your circumstances. So let's talk about physical custody. Physical custody, again, is not something that is a term that we define, but in Illinois, we do look at overnights. So in primary situations, if you're talking who's the primary physical custodial parent, you're going to be looking at the parenting plan. So who has the majority of overnights throughout the year? And I always tell people, let's start with the regular schedule. So for example, the regular schedule is usually about 10 months of the year. So that's the one that's in place most of the time. So if you have parents where one parent has alternating weekends, say from Friday until Monday morning drop off and one night during the week, just break that up. And now you've got a 2-week, chunk of time. So in that scenario, you've got Friday, Saturday, Sunday overnight. Then you have one night during the week, one night during the week. So that would be 5 overnights in a 14-day stretch. So in that situation, the parent that has the other time would be the majority parent. You could also have as close to 50-50 as you want in what I like to call a 2-2-5 schedule. That is very common these days where one parent might have Monday and Tuesday overnight where they drop off at school on Wednesday. The other parent picks up Wednesday, keeps the child till Friday morning. Then they alternate weekends where one picks up Friday, drops them off to school on Monday. And it really works out well if you want to have parents with as close to equal parenting time as you can, with the understanding that we have an odd number of days in a given year. I'm asked all the time of how does a parenting plan get put into place? And the best way I can explain it is the easiest way to do it is if the parents just agree. There are some fill in the blank forms online. You can go online, put them together, write it down, and you're good to go. Now, this is very rare, and I like to say it's kind of like an eclipse. In other words, it's not impossible, but a lot of things have to align for it to work. Reality is, if parents are splitting up, they're usually not on the same page of things. So for them to come up with an agreement without any help doesn't always happen, but it can under some circumstances. The next level up might be you get a little attorney assistance, some help with understanding some concepts. Maybe each have an attorney put some things down on paper and you get it done. After that, you're going to be involved in mediation. Mediation is where a neutral third party who doesn't work for you, doesn't work for your spouse, will sit down with you and try to help you guys come to an agreement that you can ultimately present to the court. If that doesn't work, oftentimes you'll have a guardian ad litem or a child rep, depending upon the child's age. But a guardian ad litem, or a GAL, is appointed to essentially become the eyes and the ears of the court. And their job is to go out there, interview the parents, interview other potential people that could impact this decision, and then they make recommendations to the court. Now, I always tell people it's really, really important to understand that this whole process, there's only two ways that this gets done. Either you reach an agreement or the judge makes a decision. And it's really, really important to understand that the guardian ad litem does not make the decision. A lot of GALs feel like they make it, and sometimes parents feel like the GAL makes the decision, but they make recommendations. Ultimately, it's up to the judge to do it. Now, some judges essentially rubber stamp a GAL. Some judges will actually listen to other evidence presented. So it's important that you work with your GAL, try to get the best recommendation. But if you don't agree with that recommendation, there are additional things you can do beyond the GAO. It's important that you have a good legal team that can go over those options for you and present them to you. Let's talk about modification. Now, typically courts don't like to change parenting schedules or parenting plans for 2 years. And partly is because we want to get some stability for the kid's life, but there are times where things need to change. And that can be upon a substantial change in circumstances. That's very unique, and it's done on a case-by-case situation. Say, for example, one parent's job significantly changes, which impacts their ability to have that parenting time. In that situation, well, we go back to the same principles. Can the parties agree to a modification? If so, what we need to do is we need to memorialize that agreement, present it to the court, and have it signed off so that way everyone's on the same page. If the parties cannot agree on what that schedule should be, you have to file a motion to the court. You have to say to the court, I want to change the schedule, and you have to put in the facts which would warrant that. So what has happened since we were in court? Sometimes it might just be, hey, the kids are older. They have different activities. They have different things that are going on, but it's done on a case-by-case basis. So you have to file a motion and you have to get in front of the judge. And then the kind of process will start over again. The court may send you guys back to mediation. And it's very, very common if you have a allocation judgment that there's a mediation clause in there, meaning you have to try mediation before you even go back to court. So it's really important before you try to modify anything, look at your judgment, look at your documents and see if you have a clause like that so you go to the right steps and you don't get kicked back out by the judge. Let's face it, if you're experiencing a divorce, custody, child parenting time is probably one of the biggest things on your mind. At Reidy Law Office, we understand that this is probably one of your biggest goals, and we want to help you through this. So it's really important that you have a legal team that has a structure in place to understand your goals and why they matter to you so we can create a plan of action that will hopefully get you a good outcome.